This presentation will provide the information you will need to understand RFM's Anti-Money Laundering and Counter-Terrorism Financing Program, AML CTF. The presentation will cover what money laundering is, what terrorism financing is, RFM's AML CTF program, reporting entity obligations, client services AML CTF requirements, client services procedures, verification process, direct investors, and employee due diligence. Money laundering is the process by which a person engaged in criminal activities attempts to conceal the true origin and ownership of the proceeds of their activities. In summary, the money launderer seeks to place money from the proceeds of crime into legitimate financial systems without arousing suspicion, moving money around with the intention of making it difficult to identify the original source, and reintroduce the money into the legitimate economy as if derived from an apparently clean source. Terrorism financing involves moving legitimate funds into the control of terrorist organizations. This is sometimes referred to as reverse money laundering. Terrorism financing can be raised by legitimate sources such as fundraising activities and business profits, as well as illegitimate sources such as the drug trade and fraud. Theft of personal identity information is a common method used by terrorists and criminals to operate in the legitimate system. RFM has implemented an AML CTF program to comply with the Anti-Money Laundering and Counter-Terrorism Act 2006, or the AML CTF Act. The AML CTF Act regulates financial institutions in a way which will help detect and prevent money laundering and terrorism financing within Australia. It is designed to prevent money laundering and terrorism financing by establishing an audit trail or transaction history. It is designed to meet international standards and imposes obligations on businesses offering specific services that could be vulnerable to exploitation by criminals or terrorists wanting to launder money or finance terrorism. A financial entity who provides a designated service or services is referred to as a reporting entity. To comply with reporting entity obligations, reporting entities are required to develop their own risk-based systems and controls that include client identification and verification, know your customer, KYC procedures, ongoing customer due diligence, employee due diligence, and ongoing reporting to Australian Transaction Reports and Analysis Centre, AUSTRAC. Dealer groups managed by RFM's registry with clients or investors who receive or will receive a designated service from us, as defined in the AML CTF Act, are required to complete an AML CTF customer identification agreement with RFM prior to forwarding a customer's investment application to RFM registry. The agreement sets out the procedures and the dealer group's ongoing obligations in undertaking customer identification and verification, which includes their record-keeping obligations, by ensuring compliance by their authorised representatives, advisors. The Senior Funds Administrator is responsible to ensure that agreements are sent out to all active dealer groups in RFM registry and, once received back, checked for correct completion and saved in the respective dealer group's file in the iDrive. The AML CTF agreement template can be found on the G drive under RFM, Corporate, Compliance, Risk Management, AML CTF Program, AML CTF Key Documents and Templates. As well as providing RFM with their contact details, all advisors with RFM investors are required to provide us with their ASIC, or Australian Securities and Investment Commission, authorised representative number, and their AFS, Australian Financial Services Licensee, or dealer group details. Client services staff need to cross-check the dealer group and advisor licence details on the ASIC website at www.asic.gov.au. New advisors and dealer groups should each be sent a registration form, which is contained in the advisor or dealer group welcome pack. These can be found on our website under Investor, Advisor Centre, Forms, or on the G Drive under RFM, Client Services, Templates and Tools, Forms. Once we have received the completed advisor or dealer group registration form back, the forms are scanned to the appropriate file on the iDrive before archiving. All new investor applications lodged from 1st of May 2008 require completion of the AML CTF requirements. Customer identification is done by advisors for the majority of our investors, new and existing if required. This means that advisors must undertake verification for each client prior to submitting a new application or an off-market transfer, OMT, for new buyer transferee. As there is some flexibility provided in how AML CTF can be implemented, the advisors' licensees, the dealer groups, will have required them to either complete the identification form and send it to the fund manager, for example, RFM, with the application or off-market transfer form, or complete the identification form and retain it on their client file. Receipt of the appropriate customer identification documentation is checked and confirmed by RFM registry, boardroom, and or the client services staff, almond and macadamia funds. Advisors may not be required to send in the AML CTF identification form with each new application, but are required to confirm on the application form that they have completed the AML CTF requirements by ticking the relevant checkbox on the application form. If the checkbox is not ticked or the forms haven't been provided, client services must contact the advisor directly, letting them know that the application or off-market transfer form cannot be processed until this is completed and/or verification is undertaken and provided. AML CTF legislation does not allow flexibility to complete the requirements after the event. Receipt of the appropriate customer identification documentation is checked and confirmed by RFM registry, boardroom, and/or the client services staff, off-market transfer forms for the almond and macadamia funds. For direct investors, new and existing, without an advisor. New investors who invest directly with RFM making a new application must complete the relevant FSC identification form accompanied by suitable identification documents. If there are reasonable grounds to doubt that an existing investor is the person they claim to be, investor verification must be undertaken by completing the relevant FSC identification form. The various FSC identification forms to choose from vary depending on what type of investor this is, for example, individual or company, unregistered trust, or super fund. These forms are available on the RFM website under Investor Advisor Centre, Forms. Where RFM is undertaking the verification process, the section on the relevant FSC form requiring a signature can be signed either by the Executive Funds Management or Assistant Company Secretary and Compliance Manager. Direct investors must provide one of the following ID documents: Australian State or Territory Driver's Licence containing a photograph, Australian passport, foreign passport or similar travel document containing a photograph and signature of the person, or a card issued under a state or territory for the purpose of providing a person's age and containing a photograph. The original ID document must be viewed by an RFM representative, see the previous slide, or must be certified by a judge of a court, a magistrate, a justice of the peace, a legal practitioner, a police officer, an agent or employee of the Australian Post, a pharmaceutical chemist, or an accountant. If the investment is to be held in a company name or trust, an original or certified copy of the certification of registration issued by ASIC, another Commonwealth statutory regulator, or an original or certified copy of the trust deed, trusts only, must be provided. Further information relating to the entity's trustees, directors, and beneficial owners may also be required. RFM is legally prohibited to process any investor's application unless the identification process has been completed. The AML CTF legislation does not allow flexibility to complete the requirements after the event. All completed AML CTF and FSC documentation must be thoroughly checked for correctness prior to scanning and electronic saving in the relevant client record on the iDrive before archiving. Where determined by the National Manager of Human Resources with oversight by the AML CTF Compliance Officer, new employees and existing employees who are changing their roles within RFM may be subject to the AML CTF due diligence process to ensure RFM complies with its AML CTF obligations. The due diligence process is the responsibility of the National Manager Human Resources, with oversight by the AML CTF Compliance Manager or other corporate services staff as delegated. This concludes the module.